excuse me, I'm trying to talk, sir. I am trying to talk to you.
Here's part of the problem. Your attorney is trying to save you. Oh, you know what? Don't throw your hands down. Bond revoked. Adjourn next week.
Thank you, Your Honor. Alex Warren on behalf of Mr. Hill. Mr. Hill, can you state the court?
Jose Rafael Hill. Good morning.
Good morning. We're going to need to deal with this violation.
Your Honor, I reviewed that with my client. At this time, he's going to admit to not only his behavior towards...
Why was he acting that way? You're going to have to give me an explanation for that. Those folks over there at Community Corrections have to deal with a lot of people coming through, a lot of people that are under stress, and they don't need this garbage. And certainly, and I'll be honest with you, especially Ms. Dozier, does not need this garbage. So before you start talking to me, you better make sure you understand what you're saying to me.
And Honor, before the violation issued right after the intake terminated because of behavior at the intake, Mr. Hill came to my office.
We're clear. It's not just his behavior. She had to call officers in, try to deal with it, and still tried to do it, and he still didn't do it, and he didn't complete his intake. Go ahead.
My office made me aware of what happened. Sat down with me, wrote an apology letter to Agent Dozier, sent it to her. I extended my apologies on his behalf. And I think to try and put this into context, and he acknowledges there's no excuse for it, but to try and put it into context, Mr. Hill has had medication stolen. He's prescribed medication for a mental health diagnosis. As he scheduled 2 appointments with his psychiatrist to make a plan moving forward. And after sending our apology letter to Agent Dozier, one thing Mr. Hill brought up was if his social worker was present at the time of intake, I think that might help him regulate his emotions, but he's still trying to get back on the medication that he's prescribed. So
we'll just read the letter here.
Well, Your Honor, I can answer any of the court's questions, and I think Mr. Hill can answer any of the court's questions as well at this time.
Please, I will answer. Please. Thank you. This is difficult. Very difficult what's going on. But please, I will answer whatever you need to know from me.
Over here.
I did not expect to go to that meeting and that happen. That's for sure. I'll be open. I'm an open person. And I was just opening up to Ms. Dozier about my...
No, you weren't. You were interfering with the intake process. She was just trying to get certain things done.
Can I mention something?
Go ahead.
I was talking to Ms. Dozier in a meeting, and there was some confusion. I was confused, and I was explaining to her why. Because the magistrate informed me. And if I go to when I go to community corrections, because he ordered me to go to, and I did everything he told me to do. And when we were in court, when I was in jail, and we were in court, he mentioned about corrections, and I already has experience with community corrections, so I understand that these things cost money. And excuse me, please, I'm not interrupting anyone, and I don't do that. So if I do, sorry. But once I was ordered to go there, I mentioned the judge in court. I said, Judge, I do not have any money. I just do not have any money, Judge. And he said, that's okay. Community corrections will not turn you away if you do not have any money. So when I went to community corrections and met with her in her office, I mentioned that to her. Because she mentioned it, I asked her, is this going to cost me? And she said, yes. And I said, okay, well, I don't have any money. And she mentioned that, excuse me, I'm trying to talk, sir. I am trying to talk to you.
Here's part of the problem. Your attorney is trying to save you. Oh, you know what? Don't throw your hands down. Bond revoke, adjourn next week. Take him.
This exchange shows exactly how a defendant can turn a damage control hearing into a bond problem. Defense counsel came in with a recognizable mitigation strategy. Acknowledge the conduct, show remorse through the apology letter, explain the medication issue without presenting it as an excuse, and offer practical safeguards such as psychiatric follow-up and involvement from a social worker. But Mr. Hill repeatedly shifts back toward explaining why he behaved as he did. That matters because Judge Simpson has already made clear that the central concern is not merely confusion over fees, it is whether Hill can comply with a structured intake process without disrupting staff or requiring officers to intervene. Notice the judge's warning that the attorney is trying to save him. That is a major courtroom signal. Counsel appears to recognize that mitigation is more valuable here than relitigating the underlying confrontation. When Hill continues and then reacts physically by throwing his hands down, the judge revokes bond and ends the discussion. Do you think Hill understood how much his own presentation was undermining his attorney's strategy? The hearing is now about more than an apology. It is about demonstrated compliance and courtroom judgment.
Your Honor, we can come back next week on that.
Yes.
I appreciate that.
Oh, you better keep moving. I'll adjourn this out to the 14th.
Appreciate that, Your Honor.
Here's what I'm going to do, because I think they're going to devote all their resources there, and I don't have everybody in here. Court's going to stay in recess.
All rise.
Good morning, Your Honor. James Fifelski on behalf of Benton, who is coming out soon. Please state your name for the judge.
Aaliyah Benson.
All right. Your Honor, this is a new file. I'm asking the court to adjourn for discovery.
Probable cause conference will be adjourned to May 21st, 2026, 9 a.m. Bond continued. Thank you. Oh, go ahead.
Just is present. Today, I'm requesting that the defendant sign some documents as it relates to the current care for her children. So I'm just requesting that the defense counsel review those with her and see if she will sign them, or I will ask for it to be. I hope that will be necessary.
Your Honor, I do have the documents. I don't have a problem discussing those with her. All right. And so I do plan to do that. I did fail to request if I could very briefly address bond. 30 seconds tops.
Go ahead.
Your Honor, she has a $250,000 bond at this point. Her only prior conviction, I believe, is an impaired. She's on bond on a violation of probation with Judge Barr. 5 kids she does need to financially provide for who are under the care of CPS, and there is a family safety plan. I'm just asking that you grant her house arrest so that she can at least work, provide for her children while these cases are pending.
Respond.
So I'm going to check bond at this time. This case involves the shooting of the father of a 4-year-old, the defendant's 4-year-old by her boyfriend, I believe, who has not been found. The defendant did transport the child to the hospital and then proceeded to lie about what happened and then tried to leave the hospital without seeing. So I have concerns that he has a flight risk and danger, given that we don't currently know the whereabouts of who will be her co-defendant. I have additional concerns that she will try to get in touch with him.
Anything else?
GPS tether would help keep track, for Your Honor.
Motion for bond reductions denied. Bond will continue. All right, thank you.
I'll be back, Commissioner.
These 2 hearings demonstrate an important point about bond decisions. What happens inside the courtroom can become part of the judge's assessment of whether a defendant will comply with conditions outside it. In Hill's hearing, his attorney attempted to build mitigation through an apology, mental health treatment plans, medication issues, and possible social worker support. But Judge Simpson repeatedly focused on the conduct during community corrections intake, including the need for officers to become involved. Hill's continued interruptions and visible reaction then weakened the controlled presentation his attorney was trying to make. The result was immediate. Bond was revoked, and the matter was adjourned. Benson's hearing presented a different analysis. Her attorney argued for house arrest based on family responsibilities, employment needs, and her criminal history, then suggested GPS monitoring. The prosecution countered with allegations involving a 4-year-old shooting victim, misleading statements at the hospital, and concern about contact with another person allegedly involved. Judge Simpson denied the reduction and continued the $250,000 bond. Neither ruling shown here is a determination of guilt. The practical lesson is that bond litigation is largely about risk and whether proposed release conditions sufficiently address the concerns before the court. Defense attorneys therefore need more than sympathetic circumstances. They need a release plan that directly answers the judge's specific concerns. Which argument carried more weight for you, the defendant's mitigation or the risks identified in court? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.